Hey,
Thank you. Good morning. You were so quick
Good.
on me there, and I haven't hit record yet. I'm like, whoa, you are like for somebody
I'm
on a
very eager.
Friday morning, you had your coffee, unlike some of us.
I've got my coffee right here. Very eager today. So obviously getting going, there is a new regulation regarding the movement of persons and from their place of residences. Silma, do you want to start us
Again.
off again? Yeah, again. There's a new one every week. Would you like to start us off by saying exactly what this new regulation says?
so while Silna starts off, I'm just going to share the regulation itself. It might
Great,
help.
Thank
that's
you.
perfect.
It might just help.
Thanks, Bruno. It's starting to be a standard thing, hey? Friday mornings
Yeah,
for us to
every
do this.
Friday.
It's like
Absolutely.
as much as we have our Wednesday webinars every Wednesday at 6, we're starting to have regulation discussions every Friday morning at
Yeah.
10 to 9. Also, it's such a random time. We do 10 to 9 because we need to squeeze this in between
Between
our actual
consultation.
normal practice. But thanks, it's fun to start my Fridays with you guys. Alrighty, so thanks for sharing the screen, Bruno. That helps. So let's start. I actually want to start at the bottom, Bruno. If we can maybe go to Regulation 6, I think. Yes, these directions are called the directions on a once-off movement. No, that's not the one. Repeal. So 5, Regulation 5. These regulations repeal all the previous regulations. They're on the 7th of May. So the quick webinar we did last week, Friday, has been repealed. So whatever we said there, ignore us, pretend it never happened. The only thing that is not repealed is the permits that was issued in terms of that regulation.
Yeah.
So the guys that has permits to move, don't stress the repeal of those regulations now. It doesn't affect the validity of your permits. You can still use them, but the whole rest of it was repealed. So what was repealed? The whole thing about lease agreements that had to be entered into before the 30th of April. And so for the past week, Bruno, you and I have tried to very subtly explain how people are going to get these lease agreements, and it was completely unnecessary.
Yeah.
Because now, even if the lease agreement is concluded today or any time during lockdown level 4, people are allowed to move. Okay, so now we can go up to the actual regulation. I think it's 2 there. So what we're saying is everybody can now move, and they can move their stuff. But it was limited in the previous regulations that was issued on the 7th of May. It was limited to lease agreements entered into prior to the 30th of April, and it was limited to registrations that took place prior to lockdown. What we're doing now is they've opened up all movements. So a person relocating to a new place of residence. So anybody, if you want to move back to your mum, you can move. If you want to move in with your boyfriend, consider the honestly consider the strength of your relationship, but you're allowed to move.
And the risk of going back to level 5.
Exactly, because then they
You can't move out.
Then you're stuck.
Exactly, and Bruno and I don't do it. Well, we do every now and again divorces, but we don't really want to.
No.
Wow, we're being shallow this morning. Well, just me. So you can move wherever you want to move, as long as you remain in the Republic of South Africa. Then you can move if it was necessitated by domestic violence. I must say, Bruno, why do you think they've separated that? Because I feel like if you're anyway going to be allowed to move, are you extra allowed to move as a result of?
Look, it doesn't make sense because if it is domestic violence, you would be moving to a new place of residence. So the only explanation I could possibly think is if you look at the requirements for the permit, they speak of you having to be in a possession of the lease agreements, both the expiring lease and the new lease. or the offers to purchase, or the domestic violence order. So I suppose, but it seems kind of stupid. But for example, this doesn't deal with moving back in with your parents. But I don't see how that wouldn't actually be allowed. So it's a very, very strange one. If you're going to a new place of residence, you should just be allowed to move, whether there's a lease or not, whether you're going back to your parents. But this does specifically state that the station commander would have to see a copy of the lease agreements or the domestic violence order. So it might be an oversight.
So let's talk about moving back to your parents or the moving in with your boyfriend. My advice for the past week already has been that you can do that, just submit an affidavit to explain what's happening in your life. Do you agree with me? That's going to, even though the regulations doesn't say that, I am very comfortable that, I mean, you're not going to sign a fake lease agreement with your mother or your boyfriend that you are moving in with. I do believe that an affidavit should do the trick.
Look, so I mean, I suppose it comes back down to that whole question on strict compliance versus substantial compliance. And I mean, this is something that we've always had on the substantive question of law, is if you do something to the greatest degree, but it's not to the letter, is it actually wrong or is it right? And when regulations are issued this urgently and this quickly, I mean, take, for example, oversights. So if you go to a regulation 2B, it refers over here to a number 4.
And there isn't one.
But there isn't a number 4. So at some point, somebody had a number 4 and they decided to delete it, but they didn't amend it. So you can see that these weren't properly proof checked. So there were issues with it. So obviously they mentioned all of this, but whoever drafted it didn't think, oh, hold on, wait, yeah, moving in with parents. Oh, we should maybe in that instance have an affidavit by the parents or by the kids who the parents are moving in with. So if you can get away with it and you go to the police station and the station commander is rational and goes, you know what, I'm giving you the permit because it's substantial enough, and then you're good to go. But strictly speaking, if he's going to follow the letter of this regulation, you might not get a permit.
Exactly. And I think the easy answer is, when in doubt, go apply for a permit. If you get the permit, you're going to be fine. You're going to be safe. If the permit, let's say for argument's sake, was issued erroneously, so the station commander didn't focus, clerk of the court didn't focus, we'll get to that just now, and they issued a permit for you, your permit is valid and you will be allowed to move, even if there was an error on the permit. So how you're going to know whether you can move or not is if you go to the police station or a court with your printed permit. Still, the form of the permit, is it the same as the previous? I couldn't really find a different.
No.
It looks exactly the same.
Yeah, it looks the same.
So it's the one that was issued last week already. Yeah.
We can check, but I mean, yeah, it's.
12, 6 of the one, 5,000 of the other, pretty much situation.
Yeah, it's not. So this is the permit. Yeah, so this would be the permit of the 7th. Somebody did mention that this one carried over into page 2. This one doesn't seem to. So either they've just made the font smaller or actually changed something in it.
It looks exactly.
Yeah, I think this one actually just has a larger font. So it looks the same.
So if you go to the police station or to a court and you get your permit, you're going to be fine and you're going to be able to move. But what excites me, and it really, really excites me, is in 2, again, I'm still, sorry, Bruno, I'm still on 2. It's like I'm not leaving 2. I'm stuck on that. So in regulation 2, it specifically says a business relocating to new premises. So this is beautiful. You can move your stuff, you can move your business. I had a question last week, a large engineering company, they've ordered equipment and it was delivered. Well, it would have been delivered, but they already signed a lease with a new premises. So the question was, can I deliver the equipment to the new premises and move? Because now they had to function from two separate premises, which, I mean, it was completely illogical. So I'm so happy I can send a link of this webinar to that guy to say, Lekker, you can move. So any business premises,
yes,
you can move. And this now means that if you have a lease agreement, if you sign an offer to purchase, you are allowed to move. So if you're offered to purchase now, and that was a conversation I had with one of the directors from Milton's last week, and we said, what do we do if an offer to purchase now allows somebody occupation? They had to do separate lease agreements on top of the OTPs, which I thought was so nonsensical at its very best. So now the beautiful news, please tell me if you agree with me, Bruno, is that if your offer to purchase now allows you to take occupation, or you have an installment sale agreement that allows you occupation, anything that then allows you occupation and allows you to move, or for the guys that can now take transfer under level 4 with the deeds offices, some of them now actually functioning, those guys can move and can take occupation of their premises.
I don't see why not. So over here it refers to all the transfer documents attesting to the change of ownership of property. So that would probably, or the proof of purchase. So over here it says, or the proof of purchase of residence and occupation date. So proof of purchase of residence, OTP, occupation date in the OTP, or transfer document. So they actually make it as an or, which means that you don't need to be owner to move into it. You could have bought it.
Let's talk about the transfer documents, because neither one of us are conveyancers, but I mean, we have conveyancing elements in our firms. I mean, I've seen a pack of transfer documents. It is quite something. I don't think you need to rock up to the police with that. I believe a letter from your conveyancer confirming that transfer took place is more than sufficient. You don't have to ask the conveyancer now for the whole pack of transfer documents. A letter from your conveyancer should suffice. Do you agree?
Absolutely. Transfer documents won't serve any purpose because, I mean, they sign prior to transfer, and the documents that you normally get after transfer are from your conveyancers, and they take a couple of months sometimes to actually get their hands on. So the only thing you'd have immediately after transfer is the letter, and a couple of days later, maybe like a deed search. But that's at best what you're going to need. It doesn't make sense to have anything else.
Exactly, and I thought about the deed search as well. With some of the deeds offices not functioning, and some of the, they might be, I mean, usually it reflects in about 5 days or so, sometimes even quicker on a deed search. But right now I'm worried to say a deed search because there might be a delay. And I think if we're both happy with the letter from the conveyancer, I think that will do the trick.
Absolutely.
Alrighty. There's something important. What did I miss there? Okay, so businesses can move, you can move your stuff. Transport of goods within the Republic of South Africa. So we had the question last week about moving items to Australia. I'm still saying, as long as you stay in the Republic, you can move.
Yeah, absolutely.
Brilliant, and it allows for movement of goods. Everybody is happy. And then, Bruno, you have some highlights there in 3. So I'm going to leave regulation 3 to you, if we're happy that I've covered 2.
Fair enough. Look, we've already kind of touched on it. So you already mentioned specifically. So maybe just if we compare both, all this one, you can, okay, the easiest way to say it, ignore the other regulations entirely. Because all the time and effort that we actually spent trying to explain that window period up to the 7th of June was all wasted. All the principles that we had regarding the intention of the parties to have entered into the lease agreement at a certain point, throw that out the window. None of that matters anymore. So there's no point. It's sad because we've spent so much time on it, but the reality is it actually just confuses things, which we don't need right now. So this is something fresh. Ignore that like it never happened. This says, you know what? Under level 4, people can move around. So as long as they're moving to a certain residence, so a new place of residence, exactly what Silna mentioned, there's a couple of pre-qualifications. So it has to be a new place of residence. If you're struggling with domestic violence and you have a domestic violence order, you're allowed to move to another place, and businesses. So under those three circumstances, people can move around. No limitation on dates. What they do say is it's permitted to do so during alert level 4. So everyone could have guessed this. If we move to level 3, there's going to be some other directive that's going to tell us what we're allowed to do. So this isn't going to really apply anymore. If we move back to level 5, this isn't going to apply anymore. So as long as we're sitting on level 4, we can move to a new place of residence, which means that we can start leasing our places to new tenants. Tenants can start looking for more affordable accommodation, more adequate accommodation. It's basically open market. I know that Silna's probably going to touch at a later stage regarding estate agents and viewings. So we'll get to that just now. And so far as the strict compliance with this regulation is concerned, I think every magistrate's court and every station commander is probably going to land up applying this very differently. And again, Silna probably has different experiences on what's been allowed and what hasn't been allowed. I tend to find that one person applies a very rational approach and the other one doesn't. So the reality here is you want this permit guaranteed. You need to have lease agreements. So you need to show where you are now is expired, where you're moving to. There's a new date. So that's pretty much what it says here. The date of expiry of the old lease agreement or the date of commencement. So it's one or the other. Proof of purchase of residence, so your OTP, transfer documents, a letter from the conveyancing attorney, domestic violence order, or proof of change of new occupation or business premises. So again, that's normally lease agreements with respect to business premises, or proof that you purchased, or whatever, shared offices, whatever the case might be. So the only question now comes into, you know, can you move back in with your parents? Can you move in with a boyfriend or a girlfriend or whatever the case is? That's not specifically catered for here. Silna is correct that a substantive application would allow, you know, rationality to prevail, and people would be allowed, you know, by way of an affidavit. I've spoken to some people and I said, look, bottom line is, it seems weird, but if you need to get your parents to pay rent because you don't want the trouble, get them to pay rent then. At the end of the day, the definition of a lease is use and occupation for some sort of consideration. I don't think SAPS is going to test the amount of consideration. Obviously, it can't be fabricated, but the reality is if you need to enter into a lease, enter into a lease. And if it's important to get your parents into your premises, because I know, for example, somebody spoke to me today about their parents being in a hot spot with a lot, and their parents are over 60. Sure. So they're actually trying to move people around. And in these circumstances, the gentleman actually needs to drive from Joburg. So he needs to get a permit to travel to Cape Town, collect the parents with their household effects, and move them to Joburg. So stuff like that is real. So don't mess around with it. If they need to pay rent, let them pay rent. Just get them out when you need to get them out.
Yes, I think it's, and something very important, Bruno, you've pointed it out, the date of expiry of the old lease. And I think, say for instance, so let's talk about eviction. I think this is making evictions much easier for us. I mean, we've had the debate on if somebody isn't allowed to move, are they factually in illegal occupation?
Oh, yeah.
And now I'm very happy that they are. So for the tenant that was placed on terms, so you've sent a letter of demand, and tenant hasn't vacated yet. My recommendation now is do a letter to that now illegal occupant with a copy of the permit. Make it easy. I love it to make it easy for somebody that has to move. Say, listen, here is the letter confirming cancellation of the lease agreement. That is not the date of expiry, but it's the date of cancellation. You have to move. Here is the permit. Make a plan. Do an affidavit. Say you have to move in with family and friends. And if they don't, we can immediately commence with an eviction application. And I think that is something quite important that people need to understand.
Yeah, absolutely. Do you want to maybe touch on the viewings? I know that that's something.
Yeah, we actually have plenty of questions today, specifically about what you guys are busy talking about now. So thank you everyone for your questions. We're going to get through as many as we can in the time we have. Would you be allowed, do you need a permit to move between districts? So a lot of people are moving between provinces. What exactly would you need if you need to move between districts within a particular city, such as Johannesburg or Cape Town?
Yes, I'm going to grab this one because I've touched on this in a voice note I've sent yesterday to the majority of the estate agencies. And my recommendation is still rather go and apply and ask if you need a permit. It says, obtain a permit to travel across provincial, metropolitan, or district boundaries. So my recommendation is still go apply, go to the police and ask if you need a permit. I'll tell you why. I spoke to my good friend from Steve Middelburg this morning, and I said to Wilhelmine, asked me this question, and I said, Wilhelmine, it's easy if you're in Middelburg because you're not going to go into Witbank without noticing you're going into Witbank. I mean, it's sort of obvious that you're falling in a specific district. However, I'm going to take Joburg as an example. So for everybody else that's in different parts of the country, I'm sorry, I'm going to use Joburg as an example. So say, for instance, you live in Beltevreden Park. If you move from Beltevreden Park to Linden, the chances you're not crossing a district boundary. We know that because we're attorneys and we work in the district courts. So we know, but I mean, even us have to check that book to know which districts you're in. However, if you move from Beltevreden Park into Allen's Neck, it's closer to Allen's Neck than it is to Linden, but you are crossing a district boundary. So the reason why I said in my voice note that people still need to get a permit, even if they move 2 streets down or 2 buildings down, rather print a permit, go to the police. If the police says, you know what, you're not crossing a district boundary, lekker, you don't need a permit, you've been to the police, you're safe, you're covered, you move. Say, for instance, you accidentally 2 blocks down, you cross a boundary. That's actually my situation. I live on a district boundary. So seriously, 2 blocks down from where I personally live, I'm going to cross a district boundary. So remember, guys, not all places are created equal. You're not going to cross a district line in Pofadder as easily as you're going to in Johannesburg.
Yeah,
so I would rather recommend just print a permit, go to the police, put on a mask, take your hand sanitizer, or to a court. And I think this is something important to talk about. The head of a court, so they will then probably give the clerks the right to issue this permit. So if you don't feel like going to the police because you might feel there's more people, rather go to a court. Remember, our courts open at 9 in the morning. So if you rock up there at 8 in the morning, you're probably going to be the first one in a queue. Go to the clerk of the court if you don't feel like going to the police station. Rather be safe than sorry on this whole permit thing. If you have a permit, lucky you can move. If you don't have a permit, rather don't move because you don't want to go to jail.
Okay, great. Then another one that a lot of people are asking is obviously the viewing of premises now, because a lot of people don't want to enter into new lease agreements without seeing the property first. And then another question on this too, are people allowed to, obviously if you have a vacant premises that you need to then repair or put in good condition for a new tenant, are you allowed to go and do this with a contractor? Would they need a permit as well? Maybe this 2-pronged question could be answered in the same way. I don't know who would like to take this one.
I'll take the agent side, and then Bruno,
Sure.
Then you can take the. So I think a very important message is, guys, these regulations are about moving. Now, if there's one thing we've recognized during all of this is that the property industry is so finely in tune with each other that to do one thing without affecting the others is almost impossible. But these regulations only deal with moving. And I think what I'm trying to say with that is it doesn't say, now we've opened the real estate industry. We're not allowed to do viewings. The tenant that wants to move can only view the property virtually. And so you can ask the landlord or the current tenant to do like a virtual tour of the property, even something as simple as a WhatsApp video call, to give the tenant the potential new tenant, a view of the property. But these regulations did not in any way change the position for an estate agent. I am so sorry, guys, to be the bearer of bad news. But as we said, in terms of the regulations, you have to do an inspection. Well, in terms of the Rental Housing Act, need to do an inspection before you can pay your deposit out. To do that inspection, if you are mandated as the agent to do the inspection, get your permit so you can go back to the webinar that we've done in detail on how to get that permit for estate agents. You can still get that permit, you can do your inspection. You're not allowed to do a viewing, and you're definitely not allowed to do viewings for sales. All of that can happen virtually, but it can definitely not happen physically. It's definitely not allowed. So unfortunately, agents, inspections, make sure you have your permit to do the inspection. Like I said, I prefer that you attach your permit to the specific property, to the specific tenant's permit, just for safety's sake. But viewings definitely not allowed. Repairs, Bruno, I think that's that you can grab that one.
So just to touch on what you said, I absolutely agree. And I suppose that's the problem, is it's difficult to define what is essential in order to be able to achieve the purpose of these directives and regulations. So everyone might have a different view on it. So you will have certain estate agents that are going to say, but hold on, if we don't do viewings, no one will ever want to move into a new place because that is so essential. But the problem is that it might not be essential enough. There is still a way of being able to get someone to move somewhere else without necessarily doing viewings, allowing them access to the premises, for example, or like Silna mentioned, actually doing a virtual tour. And the bottom line is the same applies to the repairs. So the construction industry isn't operational at the moment unless it's, again, they mentioned it's an essential infrastructure, certain repairs, like your plumbing and electrical. So certain services will be available, but especially when one looks at cosmetic things, it's not going to happen now. And you shouldn't be getting contractors going out to fix cosmetic issues. So sorry, cracked tiles are not going to happen. Electrical issue, that you can get sorted out. Plumbing issues, that you can get sorted out. So again, when it comes down to the inspection, you're going to need to do an inspection. You're going to need to see all the issues. It's not a matter of getting them fixed. They just need to be recorded so that when you move out, you're able to say, well, I came in, sorry, these tiles weren't fixed. They're still not fixed. Or alternatively, have them fixed at a later stage. So I'd strongly suggest, if you want to get your premises ready for leasing, make sure that the electricals are all working 100%, that your plumbing's working 100%. Short of that, the tenant's just going to need to accept it the way that it is. And I mean, for your own benefit, you know what, it's not necessarily a bad thing. You guys can always reach a compromise that it's going to get fixed later.
I agree with you. So redoing the kitchen is not going to happen right now, guys.
No. unless you can put it all under plumbing.
And then this is obviously applicable to both commercial and residential lease agreements. Am I correct?
Yes.
Yeah.
Yes.
Okay.
But, and wider than just commercial. They say business, and I must say I think it's wide enough to also talk about commercial retail as well as industrial premises.
Yeah, absolutely.
Okay, fantastic. Then we have a question. What if I am a sole proprietor and cannot register on CIPC and cannot get a permit to do inspections?
Remember, it's convenient to get a CIPC permit because that is the registered companies, but we can have this lovely example. Bruno, you and I. My firm, SSLI, is an incorporated firm, so I trade in a company entity. Bruno is not trading in a company entity, he's trading as a sole proprietor. So I can get a CIPC level 4 permit, but it doesn't mean I'm more level 4 than Bruno. I get that, and I can then issue, as the managing director, to my staff, I can issue permits for them to be allowed to come to the office. Bruno can still, even though he's a sole proprietor and he's not getting the report, the specific certificate from CIPC, he can still issue those permits. You issue your own permit, hey Bruno? How does that work?
No, it's
for yourself.
That's exactly the same. So the enrollment certificate from the Law Society confirms I'm a legal practitioner. So then it falls within my discretion almost to make sure that every permit I issue is for the services required. So I'd effectively be held liable if I go around issuing permits and it turns out that they're not performing the services that need to be performed under level 4. So all court work and stuff, I can issue permits. And I've checked this with a couple of people. So my messengers can collect documents. My secretaries are also up and down doing things. And yeah, it doesn't seem to be an issue.
Brilliant. So for the sole proprietor estate agent, my recommendation would be take your Fidelity Fund certificate, which is your proof that you are a practicing property professional. Take your Fidelity Fund certificate instead of that CIPC certificate to prove that you are a registered estate agent. And from there, issue the permits to your agents to do the inspections. That's gonna help.
Absolutely.
Okay, fantastic. Then just a few questions on clarification. So only if a tenant has a permit to move and the agent and agency has a permit to operate, can a new lease agreement be entered into?
No.
That's from one of our questions.
No, anybody can enter into a new lease agreement.
Yeah. So the lease in itself is completely separate to the regulations. So the regulations at no stage said that you can't enter into lease agreements. The problem is a lease agreement that allows for something that's not allowed in the regulations wouldn't be enforceable and would probably end up being void. But you can enter into leases. The fact now that moving is permitted basically means that any lease agreements that are entered into, the person will be allowed to move. So it's there isn't really any rationale for refusing a permit if there's a lease agreement.
Okay, fantastic. Then what is the stance on domestic cleaners? Can they go and clean a property?
No.
At this stage, do they have a permit?
So that was actually one of the examples I was thinking about. So a lot of the people, before they move in, they also get the gardener in to come clean up, do the garden, cut the grass. You can't do that. So it's not essential for the person to move. It's only essential for the person to move into a nice place, but we're not at that point yet. So gardeners, domestic workers for cleaning, I would probably say only if it comes to an actual deep cleaning, insofar as the regulations would suggest is required. So go sanitize the place. So there, it's not really the domestic worker that would be doing that. There's actual companies that get hired to sanitize premises.
I agree 100%, because I mean, my amazing Albertina, she is absolutely fantastic, but she's definitely not qualified to sanitize a place. So unfortunately, that
doesn't have the equipment. Yeah, it's a mission. Then it's rather get a professional to do it.
Great. Then also, can a landlord, not an agent, do an outgoing or ingoing inspection?
Yes, definitely, and it's because it's a requirement in terms of the Rental Housing Act. Before you pay a deposit out, or withhold for that matter, you have to do an inspection. So the landlord would be entitled to do that.
Fantastic. Then one of our members has asked if their kids have to move from Joburg to Cape Town, but their furniture is in Swellendam, sorry. Can that furniture be moved?
Yeah. Yes.
What's this stance with moving companies? Do they also they can just use the specific permit?
I would issue 2 separate permits. So I will go to the police and issue a permit to move the goods, because the regulations specifically refer to goods. So I will issue a permit for the goods going from Swellendam to Cape Town, with the truck driver and the guys that's helping with the move, the names in the permit. They then take the stuff from Swellendam to Cape Town, lekker. But then the actual person that has to go from Joburg to Cape Town, issue a separate permit for that person, because it's a different thing. Now you're crossing provincial lines, where Swellendam to Cape Town is just municipal lines. It's luckily in the same province, and a million district lines. Yeah. So I will issue 2 separate permits for that.
Yeah, and absolutely. And I mean, especially because it might involve a moving company, for instance. Like Silna mentioned, the permit needs to be in her name. You need a permit to move across the provinces. I'd always suggest, under all circumstances, just make sure that everyone has a separate permit for every small little action that they're going to attend to.
Yes, I agree with that.
Fantastic. Then there's obviously, I'm getting a lot of questions here from everyone regarding viewings. Can landlords do viewings? But I think we've already answered that question earlier in the video, which you can then just go back afterwards to just check out that question again.
Rowan, I think just for clarity's sake again, because everybody is asking this question.
Yeah, it's coming up a lot.
Exactly. Viewings are definitely not allowed. Remember, guys, the reason for the lockdown and the reason for the regulations is to curb the spread of COVID-19. I think we all sort of forget why we are doing this. It's almost day 50. So we sort of blocked out why we're doing this. The more if you do a viewing, you get in contact with somebody and you are potentially exposing yourself to a risk. I'll just tell a quick story to bring the reality in. I sprained my knee and my ankle, I kid you not, both on my left leg. So I have to go to a physio. Yes, I am that person that gets these things done in lockdown. Even not going to the gym, I can sprain stuff. So I went to the physio twice. And on Wednesday evening, I was in a webinar and I got a message from my physio saying one of the patient's wives' colleagues tested positive. And I got a major scrick, because if I then was in contact, potentially, I'm going to have to quarantine for 14 days. Luckily, the guy only went to the physio after me, but the physio is now closed for 14 days because they've potentially been exposed. So the risks are very real. And remember, for the business owners, we've been hoping and praying to open our businesses. If I accidentally, in something as bona fide as going to the physio to fix my sprained knee and ankle, got in contact with somebody that tested positive for COVID-19, I'm not just going to have to quarantine myself. If I went into my office, then I have to close my office again for 14 to 21 days. So the risks are just very real. So for the landlord and the agent, remember, agent, we are hoping and praying for you to open up again. And if we now suddenly, boom, because of viewings, increase the exposure and increase the risk of getting into contact with COVID-19, we are the people that's going to push ourselves back to level 5, full lockdown with closed businesses again. So the reality is really, it's a very big deal. And so as much as we want to do viewings, if you accidentally cross the line and you got into contact with somebody that tested positive, you're going to close your own business again. And it wasn't even the government regulations, it was your action. So don't do viewings, it's not allowed.
And I mean, it's so rightly pointed out. So now you're trying to lease a premises. Now that premises has been exposed. Now you can't lease that premises anymore, because now that premises needs to be locked for 14 to 21 days as well. So that's a burden that the landlord cannot afford to have. I know that a lot of our viewership is actually on the landlord side of things. So maybe a suggestion, I don't know if you agree with me, Silna, but if you're really struggling, so keep trying, do the virtual tours, and if people accept it, that's great. But what might work as a suggestion is if a tenant moves in and immediately, so they haven't had a chance to see the property, but immediately they realize that it's not a property that they can stay in for some reason or another. But it have to be material, not something small. Like, I didn't realize the tower was broken. Like, we draft the agreement to make it a really material. I didn't realize the space was so small. The videos were actually very, and they confused me. They were deceiving. But give as much information as you can. Here's the square meters. So now go draw it on the floor, figure out how big it is, and figure out whether you're happy with it or not. And if you truly, truly aren't, and something that we advertised didn't come to be, maybe if you get notified immediately as you move in, you could have a sort of an escape in the lease agreement, only making the lease agreement last a month or last 2 months. So let them stay there for a period. So it's not in and out. It's not a viewing.
But they can
move again. You can find a new tenant. And like this, you don't bind people to a year for a property they haven't seen. So you might just need to reword the lease agreements, add a little clause in there that gives an out in very serious circumstances.
I like that. And potentially enter into month-to-month agreements. I agree with you. It's a clever idea.
Yeah.
I like it.
Great, fantastic. If you guys have any more pieces of advice, I think we've just run out of time. So if you have anything else to say, speak now, forever hold your peace, or until next Wednesday.
Yeah. When new directors come out, that's what we do.
Until, so could be Monday again.
Yeah.
But thank you everyone for joining us today. There are a lot of comments. We have been answering them all throughout the video. A lot of people were asking for the permit. We have posted the permit on the page it was about last night around then. So just go and download the permit from there to get that all sorted. And then drop your questions, issues, anything you want to discuss at our next Wednesday webinar. And thank you so much for joining us, Bruno and Silna.
Cool.
And everyone today, have a great Friday and a fantastic weekend, everybody.
Cool.
Thank you, guys. Stay safe.
You too, you too.
Thanks. Bye-bye.
Bye.